The nation's leading Second Amendment historian, Stephen Halbrook, has just come out with a major blockbuster new historical book about the AR-15, America's rifle. We have Stephen Halbrook here to talk all about his historical work, what he's uncovered, and the absurdity of some of the attempts to ban the most popular rifle in the United States. Coming up in just 1 second. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and New York Times best-selling author. If you have not subscribed to the Four Boxes Diner Second Amendment channel, please do so. We're working really hard to try to get to 100,000 subscribers. That will make a big difference for us when it comes to the social media algorithms. Stephen Halbrook, welcome back to the Four Boxes Diner. I know you've been with us a couple times over the last many months, and thank you for coming back. And we have huge news here, which is, of course, you've just recently released a fantastic new history book, America's Rifle, the case for the AR-15. Congratulations on your next blockbuster book. For those of you who don't know Stephen has argued before the U.S. Supreme Court on multiple occasions. He's won big cases before the United States Supreme Court, including the Thompson Center arms case against the ATF. He is a former professor. He is a criminal defense lawyer. He has written countless books talking about the right to keep and bear arms both here in the United States and across the globe, including the right to carry. So Stephen Halbrook, welcome back to the Four Boxes Diner, and congratulations again on your new book.
Glad to be here again, Mark. Thank you for having me. You have a wonderful show, and I just consider it a privilege to be on it.
Well, thank you very much for that, Stephen. Well, let's just start. So you have written countless books and articles about the right to keep and bear arms. What prompted you to write what I think is now going to be the definitive book on the history of America's rifle, the AR-15?
Well, rifles were never an issue before 1989. It was always handguns that they wanted to ban. Rifles and shotguns were good, handguns were bad. But starting in 1989, we have the invention of the term assault weapon. We have the ATF imposing a ban on importation of some kinds of firearms that they called assault weapons because they didn't meet the sporting use test. We have California enacting the first so-called assault weapon ban. And so beginning in that year, I started litigating and writing about the issue of the Second Amendment rights of gun owners to have firearms like the AR-15. The AR-15 was first marketed to the civilian public in 1964. Simultaneously, the military version, the M16, was purchased by the U.S. Air Force beginning the same year. You know, we have Supreme Court decisions. We have Heller, McDonald, Catano, and now Bruin. And it seemed to me about a year and a half ago, I really needed to write this book, America's Rifle, because I feel like the next issue, one of the next big issues that will come before the Supreme Court will be whether states can ban rifles that they called so-called assault weapons and rifles that are in common use by law-abiding people for lawful purposes.
Well, that's great, Stephen. Now, again, as we know, I think you're familiar with this. I think you've written on this. What is very important, and I've stressed this on this channel repeatedly, that the Bruin methodology talks about you look to the text of the Second Amendment first as interpreted by the Supreme Court, of course. And then assuming that something falls within that text, then you go to look to see if there are historical analogs of gun control laws that are longstanding to see whether or not, in theory, you could cut back on the scope of the text. I like to say that the text giveth and the history can potentially taketh away. But what's unique, and I think you've talked about this in some powerful pieces, Stephen, is that when you deal with gun ban cases, magazine ban cases, which are really arms possession cases, the Supreme Court has already actually done all the work when it comes to the text and the history of the Second Amendment, and they concluded in Heller and Catano that provided that the pro-Second Amendment groups, if you will, can show, which is readily doable, that things like semi-automatic rifles, handguns, magazines that hold more than 10 rounds are in common use, they're protected. Game over. There is no need to review to any historical analog. So the Supreme Court has already done all that work in the prior gun ban cases. How does all that work for our audience?
Well, so Heller enunciated the test that the types of weapons that are commonly possessed by law-abiding citizens for lawful purposes are protected by the Second Amendment. That's why they invalidated the District of Columbia handgun ban. And Heller also formulated an alternative test. I think it's an alternative test where they said if the type of firearm is typically used by or possessed by law-abiding people for lawful purposes, then it's protected. So, and by the way, at one point the court uses the term commonly used by law-abiding people. Use doesn't mean, like use in self-defense doesn't mean you actually have to fire shots in self-defense. That's a fallacy that the people who advocate bans on firearms and on magazines try to argue. To use a firearm for self-defense means merely to possess it for self-defense. If you look at Heller, the court didn't require Dick Heller, the lead plaintiff in that case, to show that he has protected himself with a revolver, which was at issue there, and that he has had to fire multiple shots. Use simply means possession for a lawful purpose. So if you, the idea that you use a firearm means that you possess the firearm. You might, in fact, use it for target practice more than anything else, and any responsible gun owner would do that, to be prepared to use it for more serious purposes like self-defense. But there's no indication that under the Second Amendment you have to actually fire shots to protect yourself to make a specific kind of firearm or magazine useful. And in fact, in Bruin, the court said if it's a modern arm that facilitates the use in self-defense, then it's protected. So in Catano, we were talking only about stun guns, and the court said to the Massachusetts Supreme Judicial Court, you really got it wrong. Stun guns didn't have to exist at the founding.
Yeah, it's true. If you think about it, Stephen, in the Heller case, if you go back and read that, there's no mathematical analysis of how many handguns are in the United States. They simply say that handguns are one of the preferred methods, if not the preferred method, of protecting yourself. That's what Americans choose for self-defense. There's no analysis, no statistics, no mathematics associated with it. And what's interesting, as you know from Heller, that was decided on a motion to dismiss. There was no trial in the lower court. There was no evidence provided in any real sense. And the Supreme Court was able to say, yeah, we know handguns, we can take judicial notice, basically, the handguns are the preferred or a preferred method of self-defense. And then again, you're right, in Caetano, Justice Alito talks about there only being 200,000 stun guns. And again, nothing in Caetano talks about anybody actually tasering anybody or using the stun gun. It just says that, hey, there's 200,000 stun guns, owned by Americans in the United States in 2016, and that's common use. And like you said, common use just means owning it, to possess it. It's like using a fire extinguisher. I have a fire extinguisher in the corner of the room. I'm using it, even if I never pick it up and point it at a fire. You're still using it. It's like a life insurance policy. You hope you never have to use it, but sometimes you do, of course. So yeah, you're exactly right. It's that common use test. And there's no doubt that the anti-gun community, if you look at their arguments in court, is trying to say that the pro-Second Amendment groups, if you will, have to actually demonstrate that people pick up the gun and fire it in self-defense for it to be used. But that's clearly not what the Supreme Court indicated in Heller or Caetano or in Bruin. You're absolutely right on that. And it's interesting, Stephen, in your book, you talk about there's tens of millions of these AR-15 pattern firearms. Tell us a little bit about how this AR-15 became so popular in the United States.
Well, if you go back to the turn of the century, from the 19th to the 20th century, we already have the development of semi-automatic rifles, some of which had detachable magazines, some of which had pistol grips as opposed to straight stocks. And so you have the development over time, the improvement in the design and technology. In World War II, for example, there's the M1 carbine, which became a very popular civilian rifle. with 15 or 30 round magazines. And into the 50s, you have the redesigning of some of these different rifles, and finally in 1963, Colts, the manufacturer Colt, sent a sample rifle to what was the predecessor of the ATF, and they examined it and found that it's not a firearm or a rifle that fires more than one shot by a single pull of the trigger. It's not a machine gun. It's a pure semi-automatic. And so the following year, 1964, Colt introduced that to the public. And the same year, the first deliveries were made of the M16, which does fire fully automatic, to the U.S. military. And so the AR-15 and other semi-automatic rifles with some similar designs, like the protruding pistol grip and flash suppressor and other accessories that make it more comfortable to fire, make it a better product, essentially, for law-abiding citizens to use for both sporting use and for self-defense. That's one reason the AR-15 today has become so immensely popular. You can do so many things with it. You can put accessories on it. You can change the barrel so that you change caliber. So you end up with a rifle that's very comfortable to shoot. You might have an adjustable shoulder stock, a telescoping shoulder stock to make it fit your size. If you're a smaller person or a larger person, that makes it a family gun. You can have the younger people and the lady of the house and the man of the house, so-called, and they can adjust the rifle to their own dimensions. So that's why it's a wonderful rifle. It's a wonderful design, and it's one that the American people have chosen. Keep this in mind, because we're talking the common use test. Who gets to decide what rifles become in common use? Well, it's the population. We don't start with a test like, here's what the government allows you to have, and then you can pick and choose from that. So it's not like you live in the state of New York where they won't let you buy the kinds of rifles that you want to buy. We have a national test for what is in common use, and when you allow the American people to choose what rifles they wish to have, they choose rifles like the AR-15.
Stephen, there's a lot to unpackage here, but let's just start you've been living the Second Amendment for decades. I mean, you literally have been at the beginning of the modern fight over the Second Amendment. For so much of American history, you didn't need massive fights over the Second Amendment because people were not trying to infringe on one's rights to the extent some individuals and some politicians are trying to do today. So since you've been at this sort of from the beginning, where does this concept of assault weapon come from? Historically, assault weapon just meant a weapon that somebody used to assault somebody with. It could have been a candlestick or anything. And now, of course, it's like the modern day media has embraced this notion of assault rifle or assault weapon to refer to these just ordinary semi-automatic rifles. How did that evolution occur? Because I think you were there really when it was going on.
Yeah, one thing that's fascinating, if you do a search in a directory of legal decisions by courts, either Westlaw or Lexis, and you just use the term assault weapon as your search term, you'll find hundreds of instances where the term is used. For my favorite example is the prisoner used the broom as the assault weapon to attack the guard. Things like that. So that's what the words actually mean literally. But then we have the term assault weapon. Really, you could maybe make it related to the term assault rifle, but you have the invention of the so-called assault rifle, which is a selective fire firearm. It was the Sturmgewehr in German. It was basically designed and invented during World War II by the Germans. And again, it's selective fire. It can fire fully automatic. But then it wasn't until the 80s when the anti-gun organization, the Violence Policy Center, invented the term assault weapon to apply it to ordinary rifles, and they explicitly said this will make it very saleable to the public because they're confused. If you have a rifle like the AR-15 that looks like a full auto, like an M16, they won't know the difference. And to this very day, many people don't know the difference. But boy, is there a fundamental difference between a rifle, which is defined as a firearm that shoots only one projectile by each single function of the trigger, versus a full auto or machine gun, which fires automatically more than one shot by a single function of the trigger. That's all the difference in the world. I mean, we had one court, the Fourth Circuit in the Colby case out of Maryland, saying, well, there's really no difference between an M16 and an AR-15. Like machine guns are no different than semi-autos. Well, guess what? No military force in the world issues semi-automatics as their standard service rifle. They're all full auto. And to say it's a military type weapon, a semi-automatic it just expresses total ignorance. And it's always been, ever since under federal law, the National Firearms Act of 1934, the basic difference between a machine gun and a simple firearm, a repeating firearm. That's always been such a fundamental distinction. So this is where we are.
Well, there's no doubt this is all propaganda, Stephen. I would agree with you, total propaganda. But let me ask you this. We talked about the Colby case, which is the Fourth Circuit Court of Appeals, which I believe was effectively abrogated, although I don't know if they'd mention it by name, but effectively abrogated because it gets into that two-part test. But what's interesting is the United States Supreme Court has spoken directly to the difference between machine guns and semi-automatic rifles in the Staples versus United States case. Can you tell us a little bit about the importance of Staples when it comes to what is a semi-automatic rifle versus an automatic rifle, and how the Supreme Court might view this controversy, the so-called controversy ginned up by the anti-gunners, of course, about trying to ban these so-called assault weapons, which are just semi-automatic rifles that ordinary Americans own to the tens of millions?
Right. The Staples was a case where Mr. Staples owned a rifle. He thought it was a standard semi-automatic AR-15. It was seized by the ATF. ATF got it to fire more than one shot by a single function of the trigger. And back then, this goes back to the 80s and 90s, ATF was taking rifles, semi-automatic rifles, and using soft primer ammunition that created a malfunction called hammer follow down. And if they could get it to fire two shots and then jam, they would call it a machine gun. I assisted the attorneys in the Staples case, and that was part of the defense. But the main defense when it came up to the Supreme Court was the fact that the Staples decision by Justice Thomas said that these types of firearms, semi-automatics like the AR-15, Americans have them out the kazoo. I mean, so many people have them, and they have no concept of wrongdoing. And so the government has to prove your knowledge of what brings a weapon within the National Firearms Act to get a conviction. So you have to know that the firearm would fire automatically more than one shot by a single pull of the trigger. That's an element of the offense. That's based on the common law. We have a mens rea or intent requirements for you have to have knowledge that you're doing something that's within the purview of what's outlawed. And so Staples came out a few years before Heller, but it basically recognized it didn't use the words common use test, but it recognized that these types of semi-automatic rifles are possessed without any sense of wrongdoing by the American public, and they can be dangerous. And he said in the opinion a car can be dangerous, but they're certainly not likely to alert you to some kind of strict regulatory scheme that the federal government would impose upon you for having one.
Now, Stephen, this common use test, I think this is a very important question I'm about to ask you because there's some confusion out there among non-lawyers as to how this works. So when you're dealing with an arms ban case, meaning you're banned, government is trying to ban like an AR-15 semi-automatic rifle or a magazine that holds more than 10 rounds, and those are arms. The issue is, can the government do this? And the answer to me is undeniably no. But the government, in theory, the way they're supposed to do it under the law is if they can somehow prove, and the burden is on the government to show that these weapons they want to ban are dangerous and unusual. That's conjunctive, meaning one, you got to do both. The weapons are dangerous and unusual. And of course, kind of in response to that, if the pro-gun community can show, well, obviously these weapons like AR-15s are not dangerous and unusual because they're commonly owned by Americans to the tune of tens of millions of them, which means by definition they clearly are not unusual because they're in common use. How does that interplay work between this notion of the government can prove dangerous and unusual on the one hand, but again, if it's commonly used, there's no way for the government to show that a gun is dangerous and unusual, and therefore it cannot be banned? How does all this work together under the law historically? If you can get into that, because you talk about that in the book.
Right. So this is an interesting point. The anti-gun organizations will say in their propaganda that nobody really wants to have or nobody uses these kinds of rifles except drug traffickers and mass shooters and criminals of various kinds. But they've never been to a shooting range. You go to a shooting range today, half the rifles that you're going to see out there are going to be AR-15 type rifles. All of these rifles, when they're manufactured, records are kept, and once they go to be sold to the general public, you go to the gun dealer, and the gun dealer does a NICS background check. Every firearm that gets sold, you have to have a background check when you buy it from a licensed dealer. And by the fact that all these, hundreds of millions of people keep passing background checks, does that indicate that only criminals prefer these rifles? No. And then when we started litigating this in Hale R2, which was the first of the cases, then once that court decided against the Second Amendment, then other courts leapfrogged over that decisions. It's kind of a game that the judges play. They'll find a precedent that was decided wrongly, and then they'll cite that one, and so then you got two decisions that are bad, and then so the third court to look at it, now he can cite those two, and then it just keeps snowballing, and you keep getting more decisions, and then you have the idea that, well, most courts don't think these bans violate the Second Amendment. But let me tell you a little secret: a lot of courts never decide these cases because they're in states where there's no bans of this type. So yeah, you can find the Ninth Circuit upholding California's ban, but you won't find the Fifth Circuit upholding any kind of ban, because Texas and Louisiana and Mississippi, they haven't passed any ban. So anyway, we go back to the fact that law-abiding people are using these. And how did we first started submitting evidence? We used records from ATF manufacturing data. And we were very conservative in what we were saying about the number of millions of these types of rifles that had been manufactured. And all the courts, except maybe one to look at this, even when they upheld the bans, they agreed that these rifles are in common use. And once again, that should have been a no-brainer. We should have won the cases then. And instead, they made up the second part of the two-part test. We're going to balance your right away. Somebody might misuse one of these guns, so we can ban them. One of my favorite anti-Second Amendment decisions came out of a California court that said, well, these types of rifles that are easier to use and more comfortable to shoot, that's exactly why California banned them. And then this judge, with a straight face, not even laughing, upholds the ban because these rifles are superior. They're more accurate and comfortable to shoot. I think that's what you want. You don't want a rifle like they could ban sights on rifles if you use that kind of test. Why don't we make a rifle more inaccurate, or make it where it jams all the time, and ban rifles that are accurate, and the whole thing is crazy. We need some good decisions, and they're working on it now.
As a historian, correct me if I'm wrong, but the way I view the role of a historian, plumbers work on plumbing in a home or a building, and electricians keep the electricity running. Historians, which you obviously are, you are likely, certainly if not the top, one of the top Second Amendment historians of all time here in the United States. That's just, I think, a fact. I think most people would agree with that. And the Supreme Court, who's relied on your work, probably would agree with it too. Here's the question I have. At the time of our founding, you have Article 1 of the United States Constitution, Article 1, talking about congressional powers. One of the powers they gave Congress was the ability to create a patent office, create patents, intellectual property, useful arts. It seems to me that the founding fathers, put the clause in Article 1 of the U.S. Constitution to encourage inventions, to encourage technological improvements, and for inventors to benefit from their patents and their intellectual property. It seems to me that the founding fathers, right from the start, anticipated great technological and industrial advances all across the board, which would, of course, include advances in firearm technology. What's your thought on that?
When Thomas Jefferson was our ambassador to France, he found that French gun making entailed the new technique of making interchangeable parts. Because if you go back in history, you make all the parts for one gun and they're kind of custom made. And the idea of interchangeability was quite a technological development. Jefferson wasn't able to sell the idea very well in America, but Eli Whitney made interchangeable parts on farm equipment and whatnot. And so that's where you have, when Colt came onto the scene making the revolver, you start having mass production of firearms, better designed firearms, using interchangeable parts. And from there, it's just like any other thing in society. You have technological development in the firearms industry, and it brings to mind the fact that when you have the argument that, well, okay, flintlock muskets, that's all that's protected by the Second Amendment. Well, no, the Supreme Court said flat out in Heller, we don't impose the same requirement for any other constitutional right. Means of communication, we have the computer, we have mass production with the printing press, we have radio. None of those things existed at the time of the founding. But when you have a constitutional right, it's not frozen in time to some obsolete technology. So by the same token, semi-automatic rifles is just another, at the time, perhaps a revolutionary leap in technology, but it's so commonplace now that you wouldn't think about not having it.
Well, that gets, you get it. You just alluded to a critical distinction. We talk on this channel about the difference between Malum prohibitum crimes versus Malum in se. And as you a long-standing criminal defense lawyer, you're quite familiar with the difference between Malum prohibitum crimes versus Malum in se crimes. And it seems like these gun ban cases are Malum prohibitum. They're victimless crimes. It's like it's just made up by a politician. There's no connection to morality or rightness or wrongness in any respect. So what's your take? Can you just talk to us a little bit about Malum prohibitum versus Malum in se, and your view as to where these sort of gun ban, AR ban type efforts by the anti-gunners, how does that play out in those contrasts?
So Malum in se means wrong in itself. We've always had laws going back to the beginning of human history that prohibit that. So we're talking about killing people, assaulting people, robbing people, raping people, bad things. Everybody agrees those things should be illegal and they should be punished severely. Although we have progressive prosecutors now who don't think armed robbery is a violent crime that needs to be result in no bail to the person. But that's a fundamental basis of human civilization. But then we have, as time goes by, more and more crimes being invented by members of legislatures, the Malum prohibited type crimes, that it's only wrong because it's prohibited. And so here you have the threat of incarceration and a felony conviction to ruin your life for mere possession of a piece of metal that is a type of firearm. So if you go to the states with these bans, we're talking Connecticut, New Jersey, California, New York, now Illinois, Maryland. Those states with those bans, they punish with severe felony penalties. I think in New York even, it's a minimum mandatory 2.5-year incarceration for mere possession of a rifle because it has a protruding pistol grip. I mean, it doesn't get any crazier than this. These people like to talk about prison reform. They want to fill the prisons with people who haven't done anything wrong. So that's the severe distinction between those laws and like using a firearm in a federal crime of violence. That's a federal crime, and it should be. Or using a firearm to rape or something. That would be a typical state law. We all want criminals who use arms to be punished and for these crimes to exist. But the idea that you're going to criminalize somebody, give them a felony record, incarcerate them for not doing anything wrong to anybody, is just beyond the pale.
Yeah, and it seems to me it's even more, it's worse and more crazy than that if you think about it. So let's just take a border state situation. Let's say the state of Vermont, which has relatively good gun laws and has been for over 100 plus years, right? Vermont's had good gun laws. And you have an AR-15 in Vermont, but if you just literally cross the border to the west into New York, now for that exact same constitutionally protected item, you now go to prison for years, and all you've done is cross a border with a constitutionally protected device, and that is simply absurd. But that's that's the world the anti-gunners want to live in. They want to discourage people from owning guns. They want to intimidate them and scare them, and this is just one way of doing it. Now, Stephen, you made a reference earlier to the phrase modern sporting rifles, and this is important. You're very good at this history. Modern sporting rifles versus semi-automatic rifles. You did a great job in this book of talking about where does that phrase modern sporting rifles come from versus the phrase semi-automatic rifles, which is what Brett Kavanaugh talked about as a judge in the Heller 2 case. How does this work, and how did this phrase modern sporting rifles come about? Because it's a very interesting history involving import-export law that I don't think that many people know.
There's been a movement to ban handguns ever since the beginning of the 20th century. You've had these do-gooders. A lot of them were the temperance people, the prohibitionists. They kind of went along together. They're nanny-type people. So you have the use of the term sporting arms actually can be an industry term as well. If you've got like a shotgun designed specifically for waterfowl, that's a sporting shotgun. But it wasn't until 1968 that Congress passed a law requiring imported firearms to be particularly useful for, I'm sorry, let me get the formulation right. Particularly useful for sporting purposes or easy to convert from sporting purposes. I'm not quoting it exact. Readily convertible to sporting purposes. It's for importation. So you have this invention of the sporting test. And so it's a general recognition test. ATF usurped that general recognition. It says that it owns the idea to determine whether something is sporting as opposed to like the public at large. And so basically rifles and shotguns, as long as they were not NFA types, could be imported ever since that law passed in 1968 up until 1989. Handguns were subject to what's called the factoring criteria. Like the baby Browning was non-importable. It's too little, even though you could use it for sporting purposes like in your fishing tackle box. But larger handguns are importable under the sporting test. So in 1989, after ATF had for years been regarding semi-automatic rifles as sporting, passing the sporting test, particularly suitable for or readily adaptable to sporting purposes. That's the phrase I was looking at, trying to remember a minute ago. All of a sudden, the rules changed, and you had the Bush 1 administration saying that, well, we have to ban the imports of some of these guns. We don't really know what they are. So they first banned import of 5 semi-automatic rifles, and there was litigation, and finally ATF expanded the ban to include most semi-automatic rifles, if they had anything that even looked like a military feature, like a protruding pistol grip. So that's how the sporting test got into federal law. There's no domestic requirement that a firearm meets some kind of sporting test by some government bureaucrats' thought. So eventually we have the use of the term modern sporting rifle. You might just say modern rifle. The rifles that we're talking about are used for sporting purpose, but they're also used for self-defense and other reasons.
Yeah, and as Brett Kavanaugh said in Heller too, these are just really, at the end of the day, semi-automatic rifles. You pull the trigger once, it fires one round. And yeah, that notion of sporting sounds like that came out of the import-export context of commercial, the work of the National Shooting Sports Foundation, which is great work. But yeah, that's a very fascinating history. Stephen, there's another interesting discussion of some of your historical work. That is, and I found this quite interesting, that at the time of World War II, there was a discussion about property requisition. I think this is in the months leading up to Pearl Harbor. There was a discussion of property requisition, meaning if we get into war with the Japanese or the Germans or whomever, we may need to requisition and convert, auto plants into munitions plants or whatever. But it looks like from the history you've done over the years that many members of Congress and even the Roosevelt administration said, we don't want a situation where we're taking guns away from Americans because we see what happened in Europe. So can you tell us a little bit about that history here in the United States when Congress before World War II was talking about property requisition and how they treated the right to keep and bear arms in that context?
Right. So if you go back to the National Firearms Act of 1934, the administration, the Roosevelt administration, argued for a registration of pistols and revolvers, and that got taken out. But the Roosevelt Attorney General continued to advocate a national registration, basically of all firearms, and that was never acceptable. It was never even voted on in Congress. But when you have the leading up to this law that was passed in, I think, about September of 1941, to requisition lots of things in society, the pro-Second Amendment people in Congress were not going to allow that to be used to confiscate firearms. And so they put in a clause there in that law as passed that nothing in this law can be construed to allow the registration of any kind of firearm not already required to be registered, that'd be NFA. And it reaffirmed Second Amendment protection for firearms that can be used for self-defense and sporting use. And the proponents of that legislation said, yeah, look at the Gestapo, look at the Cheka, that was the Russian secret police, one of their organizations. They confiscate firearms. So that was well known at the time. I mean, the Kristallnacht in Germany in 1938, the Jews' firearms were confiscated. They were registered. And then every country that the Nazis conquered, they collected all the registered firearms, and they shot people who didn't turn them in. The Russians did the same thing when they went into Poland, divided up with Hitler. So that was something that the pro-Second Amendment members of Congress were not going to let the administration get away with. They didn't trust some of the government officials in terms of this whole issue of registration and confiscation, and that's how that got into the law. And it showed once again, as existed in other times of its history, Congress always had an individual rights interpretation of the Second Amendment, and always felt like the Second Amendment protects arms that whether it's for sporting use or self-defense or other lawful purposes, that's what is protected.
I know this is not specifically what we're talking about in the context of banning AR-15s and the history of AR-15s, but I think it's worth discussing because you were very important in the Heller case before the U.S. Supreme Court. Can you just talk and remind our viewers, what is the interplay between the prefatory clause of the Second Amendment referring to a well-regulated militia on the one hand, and then the operative clause of the Second Amendment, which refers to the right of the people to keep and bear arms, shall not be infringed. How do those two clauses work together consistently, as understood by you and by the Supreme Court?
So it's not unusual for one of the amendments to have more than one clause. And what's interesting about the Second Amendment, they really do complement each other. A well-regulated militia being necessary to the security of a free state. That enunciates the idea that an armed populace, because that's what a well-regulated militia is necessary for a free state. And the idea was we don't want to just depend on a standing army. Our founders were very afraid of what a standing army could do because they experienced it, like the Redcoats. Hello. So then we get to the operative clause, the right of the people to keep and bear arms shall not be infringed. That enhances the well-regulated militia. If you have a population where the right is recognized, then you're more likely to have able-bodied people who are armed that you could draw from for this militia, which could be in an emergency, or it could be something just to have a formal militia. So there never was any conflict between the two. It was not until about the 1960s when you have the invention of the so-called collective rights view, which basically says this. We've got the militia clause. It overrides the right of the people. So it really doesn't mean the people. It really means the states. It really means that the states can have a National Guard. And by the way, the people enunciating that theory hated the National Guard. This was in the 60s. The National Guard was being called out to put down student protests on university campuses. But now all of a sudden they're the guardians of the National Guard. So you have the invention of that theory, and then after the Gun Control Act of 68 passes, you actually have federal courts making up and accepting this collective rights view. They would cite the Supreme Court's Miller case from 1939, but Miller never said a word about collective rights. In fact, he presupposed that the Second Amendment was an individual right. And so then we go through the 60s and the 70s and on and on. And if you go to law school, the idea that the Second Amendment was worth studying was non-existent. If anybody mentioned the Second Amendment, you'd be ridiculed if you said, well, yeah, it says the people, the right to keep and bear arms. Doesn't that mean you can carry a gun? As set forth clearly in Heller, you have the preamble or the precatory clause about the militia, and then you have the operative clause, and that's what really counts. And so they completely did away with this collective rights trash, which was nothing more than an excuse to say nobody has Second Amendment rights, and therefore every gun law, every restriction is valid.
Yeah, that's very powerful arguments, and you're certainly right. And the Bill of Rights is obviously referring to individual rights, because I don't think states have rights. I think states that really have powers. But you're absolutely right that the right of the people to keep and bear arms is a necessary condition to have a well-regulated militia, because, the idea, as I understand it, Stephen, you tell me if I'm wrong as a historian, but, Americans had their own firearms, they had their own ammunition, they had their own weapons and whatnot. And when they were called out for militia musters at the time of our founding, they would bring their commonly owned firearms and weapons to the militia muster. They would not only do it, but in many instances they were required to do so. Is that fair to say that Americans would bring their commonly owned guns that they own privately to militia muster, at the time of our founding?
This goes back to the settlement at Jamestown in the 1600s. Every settler was required to bring their own gun. And if you go up in history to the Federal Militia Act of 1792, every able-bodied white man was required to have his own militia-type arm and to bring it to muster and to be ready to be mobilized in event of an emergency. And I think it was 1867 the word white was stricken out because African Americans were deemed to be citizens by that point. Slavery had been abolished. And so it was always required to have your own gun. That was not taken out of the law, actually, until the early 1900s. No longer became mandatory to have your own gun. It had not been enforced very much. and that's when the civilian marksmanship program came onto the scene, because okay, we're not going to require every able-bodied man to have his gun, but we're going to make these military rifles available so that those who choose to do so can participate in marksmanship and learn the skills and better exercise their Second Amendment rights.
So, Stephen, I really appreciate you giving us your time today. This is invaluable information to get out to the Second Amendment community. But I want to talk about a current controversy that, President Joe Biden repeatedly has been making this point that if you want to take on the government, I don't know what he's talking about, but he's like, oh, if you want to take on the government or whatever it is, you need more than an AR-15, so we can just ban AR-15s. Set aside kind of the internal contradiction of his statement, because AR-15s are weapons of war. Or not weapons of war. I don't even understand what Joe Biden says half the time. But what I'd like to talk about, is there a history of using small arms to, ultimately capture larger arms and larger arms? I think maybe, issues like the Liberator in World War II, whether or not that was dropped in France. Benedict Arnold, back before he was a traitor, when he was an American patriot, he used small arms to capture cannon and all this. Can you talk a little bit as a historian about the role of using smaller arms to capture bigger arms, and so on and so on and so on? Because it seems to me that is the history of the role of small arms in playing a role in defending against tyranny and foreign invaders and the like. How does all that work from your point of view as a historian?
Yeah, just a comment about Joe Biden. He threatens to eradicate populations with fighter bombers and all that, but it's a fact, though, that small arms can be used to resist tyranny. When Russia first attacked Ukraine, there had been a lot of firearm restrictions in Ukraine, unfortunately, but immediately you had people buying up all the semi-automatic rifles they could, and you had training of civilians. You can see photographs from those first days where men and women, old and young, have plywood cutouts of AK-74 rifles, and they're showing them how you shoulder the rifle and how you aim it, and there was a huge demand, obviously, for small arms, and you can use small arms. They've used small arms in the Ukraine context as snipers to knock out Russian generals, even. So anytime you have potential for urban warfare or jungle warfare, whatever the context, you have definitely a role for small arms. And we saw this in the Middle East wars. We saw it in Vietnam. So people in these conflicts with small arms can do a lot, and they might be able to liberate their countries. I mean, we always had, in the Revolution, we had the small arms, and we didn't have the bigger arms until we captured a lot of them.
That's right. Well, Stephen Halbrook, you are the author of yet again another great Right to Keep and Bear Arms book, of which you've done so many. The America's Rifle, the case for the AR-15. Is there anything you'd like to add as to why it's important for the Second Amendment community to understand what's in your book, the history there? Anything else you'd like us to know, to understand about what you found in the context of this book, or anything like that? We'd appreciate your final thoughts on that.
Well, I think what I've tried to do is amass every constitutional argument, every historical argument, every legal argument that's possible, to show the background, history and tradition of why these modern rifles are protected by the Second Amendment. These are the rifles that people without knowledge of what they really are want to ban, and I think it's unacceptable in our society to ban them. It's against our constitutional rights. The types of rifles we're talking about are very fine rifles. They're used for good purposes by law-abiding people, and as part of our Second Amendment heritage, we shouldn't be so quick to ban them and to seek to incarcerate law-abiding people for mere possession of these rifles, just because, and they're identified by, okay, a Colt AR-15 or these different models and makes, and you've got the generic classifications to ban them, like the protruding pistol grip, which is so scary. I mean, it's not scary; it's ridiculous. They're going to incarcerate you for something, for just the shape of the grip. It goes against every principle of liberty. So the book's available in paperback and in Kindle, and if you are interested in the subject, get the book.
Well, Stephen Halbrook, thank you again for joining us here at the Four Boxes Diner. Everyone who views this channel loves Stephen Halbrook. The comments that we always get when you come on are fantastic. People appreciate all your many decades of work in support of the right to keep and bear arms, and I'm looking forward to seeing more and more of your work down the road. But again, America's Rifle, the case for the AR-15, I cannot think of a more timely book that the Second Amendment community needs than this book. And congratulations again for yet another wonderful piece of history that you've put together, figured out, and written up for all of us to enjoy and learn. And again, thank you so much again for joining us here, Stephen Halbrook, historian, Second Amendment guru, and we appreciate all your time and effort in this.
Orders up. Table 2A.